does this person deserve to die? I think the question needs to be rephrased, right? Clearly they've done something wrong and some consequences need to be attached to that. The true question that we need to ask, though, is do we deserve to kill them?
Death penalty. There's been about 200 death sentences handed down, 189 actually, about 155, 160 people. The reason for the difference, some people get multiple death sentences. Patrick McKenna was sentenced 4 times to death, overturned 3 times. Tracy Petrocelli 4 times to death, 3 times overturned.
This also ties into something else that we're dealing with here that we are also litigating, which is the chemical veil, which is a drug added to the drug cocktail solely for the purpose of making an execution look clean when it's not, right? That if something goes wrong, the general public won't know what's happening. And so it raises a question about what can a government do to essentially lie to the public, right? Are they allowed to do things specifically to hide things the public would obviously have an interest in?
I'm willing, I think John's willing to sit down with prosecutors, anyone else to have this discussion, because I think the facts are pretty clear once they get out there. I think hiding the facts, putting a veil over the facts is what's kept the death penalty in function as long as it has.
This is our Nevada Judges. I'm Emily McFarling, and joining me today we have some panelists to discuss the topic of the death penalty. I'll turn to our panelists to introduce themselves. John?
My name is John Pirro. I'm a Chief Deputy Public Defender with the Clark County Public Defender's Office. I also do the legislative liaison work, so I was heavily involved in the 2017 and the 2021 repeal efforts that ultimately fell short in the Nevada legislature.
My name is Chris Peterson. I'm the legal director at the ACLU of Nevada. We have some ongoing litigation in federal court related to First Amendment rights to access related to the death penalty, specifically the execution of Zane Floyd.
I'm Scott Coffey. I'm a Chief Deputy Public Defender with the Clark County Public Defender's Office. I've defended homicide cases for the past 20 years, including capital cases. I track the numbers for Nevada as far as death penalty and that sort of thing. I've been involved in the legislative efforts since 2005, 2002, so long time.
Welcome. So just to start out, what is the death penalty?
Coffee, if you want to attack that.
Well, the death penalty is sanctioned murder, for lack of a better description. It is society getting together and deciding somebody doesn't deserve to live anymore and executing someone. At least that's the theory behind the death penalty. In practice, it's incarcerating people and guaranteeing appeals for decades.
Is the death penalty legal in Nevada?
Yes, and has been since 76. There was a moratorium in the United States from 72 to 76, and it was reinstated in Nevada since 76. When we talk about things, in fact, I think it's what we'll probably be talking about is after 76.
Okay. And what types of execution are legal in Nevada?
Currently just lethal injection.
And how many of the 50 states is the death penalty legal?
So it's a moving target. It's about half. 23 officially have got rid of the death penalty completely off the books. The latest being Virginia, which is fascinating because it's a very conservative state. Utah is on the cusp of getting rid of the death penalty. Of the half that have the death penalty, I would say, at least 2/3 don't use it in any way, shape, or form. Either haven't executed anybody in the last 10 years, or they just haven't sentenced anybody. They don't seek death sentences. It's active in about 10 states.
And if I could just jump in on that a little bit. So I would say it's a little bit less than half. As Scott has said, 3 states currently have a moratorium on it: Pennsylvania, California, Oregon. Those are governor-imposed moratoriums. And there was a recent Oregon Supreme Court opinion that may effectively abolish the death penalty the way it's in the books now in Oregon. So we currently, as Nevada, we're an outlier. There's less than half that have it, and we're sitting in the bad half that still currently do have it.
Mm-hmm.
And you mentioned that there was a moratorium prior to 1976. Was that in Nevada or across the United States?
Across the United States. There was a case called Furman versus Georgia that said essentially that capital punishment couldn't be imposed fairly, that violated due process. That was in 72. It was reinstated with somewhat of the current structure that we've got in 76 by a case called Gregg versus Georgia. Again, Georgia was actively involved in the death penalty, still is.
And how many times has the death penalty been sought in the United States since that decision in 1976?
thousands, many thousands. Nevada, we don't even have good numbers for Nevada, but I'd say it's well north of 1,000, just using a little bit of extrapolation in Nevada, that it's been sought. It's not been imposed that much. The impositions or even the sentences of death are substantially less.
And about in Nevada, about how many times has the death penalty been sought in Nevada since that 1976 decision?
I would say more than, again, I'd say well more than 1,000. Somewhere between 1,000 and 2,000 would be the best estimate. Nobody kept numbers for years. Nobody knew how often we were seeking it. But you can kind of work backwards. We've sentenced about 200, we've handed down about 200 death sentences in Nevada. And it only happens in about 1 in 10 cases now when it's sought. A little more often in the past. So I would say north of 1,000 is a safe number.
And I would just say, as far as Nevada goes, and what Scott's saying is, we have not really kept accurate numbers on what we've been doing in the criminal justice system as a whole, and that's been a major problem. We haven't really been using evidence-based solutions to move anything forward. It was not until 2019 where the Criminal Justice Institute came in and looked at all of our criminal laws and said, here are things that you can change. So in 2019, the passage of AB 236 came about. That bill changed, for lack of a better term, criminal justice in Nevada. And it was the most substantial change in the last 30 years. And now we have a sentencing commission that is looking at numbers, seeing what's going on and saying, okay, if we're going to change the law, if we're going to do something that is going to increase criminal penalties or continue to incarcerate people, we're going to take a look at the numbers and see why we're doing that, which before we did not do, as Scott was saying. And so that's why the numbers in the past, before Scott really came along and started tracking things, are not accurate and difficult to track.
In fact, it became a necessity. I mentioned we were involved in the legislative process a couple of decades, and it became clear we were getting bad information, that parties with an agenda were coming in and putting disproportionate numbers out there or just misrepresenting things, to be quite honest. So we started tracking the numbers, case numbers, names, everything that we could put together, so we can get an accurate picture of what's going on. What we found is pretty disturbing, but I think we'll get to that in a few minutes.
Okay. And I think you just mentioned that there's been about 200 people sentenced to death in Nevada since that 1976. Is that about right? And
yes.
that's since you've been tracking numbers.
It's a very weird animal, this death penalty. There's been about 200 death sentences handed down, 189 actually, about 155, 160 people. The reason for the difference, some people get multiple death sentences. Patrick McKenna was sentenced 4 times to death, overturned 3 times. Tracy Petrocelli 4 times to death, 3 times overturned. So you have people sentenced multiple times, so it raises that number a little bit.
That's interesting. And of those roughly 150, 200 people, how many of those have actually been executed in Nevada?
12. Almost none. So 12 out of it's less than 10%.
And that's since 1976?
Since 76. And none in the past 15 years.
Wow.
The concern is, right, that this past legislative session, the District Attorney Steve Wolfson actively sought a death warrant for Zane Floyd. So although it may have seemed like we were having an academic debate about the appropriateness of the death penalty, it became a very real concern this last legislative session. It is no longer an academic debate when Steve Wolfson is actively trying to kill another human being. So now, all of us in the Nevada Coalition Against the Death Penalty have a large concern of trying to stop this train.
Yeah, and John makes a great point. I mean, the federal government had a moratorium for years, and under the last administration, we basically started lining people up and executing them at a much higher rate than
6 people before the Biden administration took effect. Donald Trump's administration murdered 6 people.
Yeah, compared to almost nothing in the 2 decades beforehand.
Wow, and that's federally?
Federally, yeah.
Wow.
Yeah. And just as an aside, if I might, the 12 people are actually kind of fascinating because that's an inflated number also. And what I mean by being an inflated number, we've executed 12 people, but 11 of those people volunteered. They said, I quit. I don't want to be on death row anymore. I give up. I'm done. And they just voluntarily were executed. Right. We've only executed 1 person who hadn't volunteered, a man named Richard Moran, history of mental illness, who represented himself at trial.
Wow.
Yeah.
So 11 of the 12 people who've been executed in Nevada since 1976 just voluntarily said, okay, fine, do it, and only one of them was objecting to it.
And Moran didn't actually object on the last day. There's a whole interesting story there too. He went in and pled guilty by himself, pro per, no attorneys. There was questions on appeal whether he was even competent to go forward, had a long history of depression, went all the way to the United States Supreme Court. And he had some avenues left that he didn't take on his last day. I know the attorney that represented him, and chose not to do it. So we don't, up to now, right? Fingers crossed, as John said, it could always happen because we've seen what happened in the federal government. But as a practical matter, it's very difficult to actually follow through with a death sentence.
And is that one reason why 11 of the 12 have at some point said, fine, just do it?
And that's disproportionate. And I'll let these gentlemen speak to it, but it's disproportionate. It has to do with the conditions on our death row, I think.
Right. Well, I mean, that's the key thing, right? That people who are sentenced to death are treated differently while incarcerated than other prisoners. They're not in general population. They're kept on death row up, I believe right now it's at Ely State Prison. And there's also the added psychological effect, which is you don't have finality, right? As things are pending and dragging along, you know that death is waiting for you at the end. But after appeal, it wears people down. And there are people that it is so psychologically damaging, they'd rather be executed than continue on dealing with appeal after appeal. And you look at something like, for example, what's going on with Zane Floyd right now, when you have a district attorney that decided to push forward for openly political reasons to kill him. I mean, that's a very painful circumstance to be living through, And I think that's something that people don't realize, that cost of things. It's not just about the death at the end. It really is sitting in very restrictive conditions for decades.
Well, with people who, by and large, a significant number of these people have severe mental illness.
Yes.
Schizophrenia, other things. They can't be housed safely with other individuals. They are self-injuring. And you put them in an isolated box 23 hours a day where they can't get out. And it becomes, a desperate situation. They're willing to do anything to leave, including be executed.
And to tack onto that, just for the larger criminal justice picture here, the Clark County Detention Center is the largest mental health facility in the state of Nevada. Over 1/3 of the people in that jail are on some form of psychotropic medication. So we are dealing with large-scale mental health issues, as Scott said. And then I think Scott Dozier's words, the man who killed himself after seeking to voluntarily be executed, his words, I think, ring true in that life on death row is not a life, and that's why he took his own life.
Tell me a little bit more about Dozier. What happened there?
So Scott Dozier was sentenced to death. There were a number of, he was involved in a number of illegal activities, drug dealing, that sort of thing. Implicated in a few murders. He claimed factual innocence on the one that he was actually sentenced to death row on. He became despondent. Unlike a lot of the people with mental illness, Scott, very intelligent, IQ 130, 135. And he decided he wanted to be done with things. He volunteered to be executed, asked to be executed. But the state of Nevada, the methods that they wanted to use for lethal injection had the possibility of causing some pain. I think Dozier realized it could have hurt other people too. You've had botched executions all over the country. Ohio had 2 or 3 in a row. Mm-hmm. And Dozier litigated what drugs were going to be used. The litigation took so long, Dozier ended up hanging himself in his jail cell, which is a very, very hard to do, and you have to be very determined. The way that death row is, there's an air vent that's about 10 or 12 feet high and concrete walls all around. He managed to hang himself from that air vent.
It's my understanding in that Dozier case that there was drug companies that were also litigating, trying to have an impact on what was happening with that execution.
Yes, happy to talk about that. I think that something that's often forgotten is that there are parties outside of the criminal case that have an interest in what's going on. And the pharmaceutical companies get involved because they do not want their medicines to be used to kill people, plain and simple. And in fact, the contracts that they make with the states when the states purchase their product is that it will only be used for medicinal usages, right? Because that's why they went into that business. And so the pharmaceutical companies have a moral stance against their products being perverted, that something that's meant to prolong life is now being used to kill somebody. So they step in and they enforce their contractual rights to not have the medication be used in the executions. That happened with Dozier. It reared its head again in Floyd. Hikma, the pharmaceutical company, was very angry that their medicine was going to be used to kill Zane Floyd. They stepped in, sent a cease and desist order, or a cease and desist letter that was referencing the previous case they filed against the state of Nevada where they won. And it was very clear that this wasn't supposed to be used that way, especially because this ties back into sort of the subterfuge that's used by the state in these executions. They don't like to let people know what drugs they're using or where the drugs came from, because the pharmaceutical companies do not want that to be used that way. They know they're violating their contracts with the pharmaceutical companies. And so in turn, they know that if it gets out and the pharmaceutical companies recognize that their drugs are being used this way, they're going to intercede and they're going to tell people, you're violating your contract with us.
It becomes like the old Mad Magazine cartoon Spy versus Spy, where the prison and the state of Nevada is using clandestine means to try to get these drugs. They can't get them directly, so they will send people out of state. They will buy them out of the country. The FDA has actually come in and seized drugs in Kansas that were illegally gotten to use for executions. So none of this is done above board. There's no transparency in any of this process. They fight to keep who they got the drugs from. They fight to keep who the supplier is. Cardinal Pharmaceuticals, in the case, Cardinal was the middleman in the case of in Dozier's case for Hikma and Alvogen. It is fascinating the lengths the state will go to try to hide where these things come from. And there's moral interest. There's also an economic interest for these drug companies. Most of these drug companies are worldwide. They do business with the EU. The EU does not have the death penalty, and their countries are staunchly against the death penalty. If you want to join the EU, you have to get rid of the death penalty. A few Eastern European countries have had to do that, and they worry about backlash. They worry about protest, about people refusing to use their drugs if they're involved in execution. So it's a very serious thing for these drug companies, money-wise and moral-wise. And that's what the suit was about.
Mm-hmm.
Are there any other people or entities that don't want to be involved in executions that can, cause issues, such as, a doctor who might need to administer the drugs?
Oh, you had that just recently. You want to talk about that, Scott?
Either one. You can too. I can chime in.
There's news that came out recently that the EMTs that would have been involved in Zane Floyd's execution have backed out at this point. Because I think at the end of the day, I think especially considering that if you think about lethal injection in particular, it's a subversion of the medical profession, right? It is something that you are using people's skills who have been trained to heal, right? They've been trained to prolong life, to kill someone. And to do things like, for example, when you talk about the drug cocktails, not just kill somebody, but often hide the suffering that is involved in the killing of that person. That there's chemicals that are intentionally put into the drug cocktail to sole purpose is to paralyze the individual, so you cannot tell that they're suffering. The description is they can have fire in their veins and you would not know because they cannot scream, right? Because there's a chemical in there that has no purpose as far as killing someone. It is solely to keep them in a place where they're unable to move or to show that they're in pain.
It's a real problem. The statutes call for somebody with medical training to be on hand, a doctor ideally. I think the statute may call for a doctor. They don't want to disclose who they are because they're afraid it will cause problems with their medical license. They're afraid they will become a pariah in their community. They're afraid they'll be targeted by a variety of groups who figured out that the death penalty is really broken beyond repair. So when in federal court, when they were going to disclose the names, the doctors dropped out. We don't have a doctor to stand by for the Floyd execution. We don't have EMTs to stand by because we're going to disclose those names, which are all should be part of the public record. I mean, if we're going to do this, we should do it with clean hands and above board. But the state desperately tries to hide these kind of facts.
Very interesting. When's the last time Nevada executed someone?
Boy, it's been 15, 17 years. It's been a long time. I believe Darren Mack was the last person executed in Nevada.
And about how many people are currently on death row in Nevada?
Again, like all these numbers, they move. It's about between 60 and 65. And I say that because it's interesting. You have people on Nevada's death row who had their convictions overturned who can never be executed pursuant to federal court orders. But because there's other things pending, they remain housed on the row. So it's a strange, all this stuff is very nebulous when you start to get into the details.
The last number I saw from the Death Penalty Information Center was 66, but Scott is right. It was a big change from the year before. What I will tell you, though, what I can tell you is that puts us ninth in the nation. Nevada is ninth in the nation for people on death row. And that's not even counting all of the cases that Scott is probably going to tell you that have been filed by Steve Wolfson since 2012 as a district attorney that are awaiting a trial to see if the death penalty will be imposed.
Yeah.
If those cases go forward, which we have great attorneys in our office, so I do not assume that the state would win all of those cases. But if those cases went forward and the worst were to happen, we could probably be bumped up ahead of Arizona, which would put us at number 8.
And that's you have to remember, this is a historical question to some extent, because a lot of the people that are on death row have been there more than 2 decades. More than 2 decades. We have people like Tracy Petrocelli, who recently died. Patrick McKenna, that I've mentioned before, recently died. They've been there since the late 70s, early 80s. That's not unusual for the people that we have on death row, those 63, 65, 67 people.
And when you say they died naturally, sitting
Yes.
on death row?
Yes, you're more likely to die of natural causes on death row than you are to be executed, even if you volunteer.
Interesting. And you mentioned a minute ago that there are some people that are on death row who had their convictions overturned, but they're still on death row?
Yes, it's very strange, right? So if competency becomes a question, they can't proceed through further legal process. So, for example, they might be attacking their underlying conviction. That is still pending. They've not finalized because they're still attacking the underlying conviction, not just the sentence, and they just sit on death row and languish. I had somebody who sat on the row for 10 years after having his death sentence overturned, awaiting a new penalty phase. Eventually that case resolved to something less than death penalty, but that is not unusual. There's not a real clear distinction on who we house there and who we don't when their sentences get overturned and when the courts get involved.
And just for clarification, competency is when a person is too mentally infirm to even understand the proceedings that are going on against them. And doctors have found that. So then everything gets put on pause until that person can be restored to competency, which is a little bit different than mental illness as a whole. And competency is not a very high bar. So if somebody is incompetent, they are extremely mentally ill.
And when they look at competency, are they looking at the competency of that person when they had their trial or when they're to be executed?
Well, both. So due process requires, obviously, that a person be competent to go forward with trial. You don't put someone who's incapacitated or in a coma on trial, right? It would be fundamentally unfair. And we have the same thought process for executions because the death penalty is arguably about retribution, regardless of what anybody would like to say. It's about retribution to some extent and punishment. There's no punishment aspect if somebody doesn't understand why they're being killed, if they have the mentality of a 4-year-old. And we have people like that have been on death row. People who've got Alzheimer's on death row, those sorts of things. And that will put everything on pause.
The other way of thinking about competency is that if you look at the caption on a criminal case, right, it's the state of Nevada versus the defendant. So the idea is that you have these two entities, two people duking it out. And in every criminal case is fundamentally unfair, right? The state of Nevada has incredible resources. Obviously, they have whole departments, police departments that are their investigative agencies, right? Versus a defendant who gets assigned an attorney that they often get assigned an attorney. They can hire someone if they have the money, but often get assigned an attorney, right? Hopefully, there's plenty of competent public defenders, but, they didn't choose that individual. And often public defenders also, there are further limitations on investigative resources in a lot of situations. But in some ways you can think of competency as we have not set a high bar on making this a fair fight. Competency is the bare minimum, which is, you actually cannot participate in your case. You either do not understand what's going on, or you are so disabled that you can't actually help your lawyer. And at that point, we'll say, okay, well, we'll pause it long enough for you to get kind of back in the right frame of mind for us to put you back out there in a fight that's fundamentally unfair. But until you get there, we won't beat you up right now, right? And so that's the way they view it on, during the entire court process. While they're trying to convict them, they'll pause the train long enough to get that sorted out, send you to some facility to get treatment, and then they'll start back up again when you're ready to go. So,
how many, what number of people who have been sentenced to death end up having competency or mental health issues?
Well, it's hard to say, and that's part of the problem. It's very difficult to get into death row. So the federal public defenders do a good job. Inevitably, if you're on death row, you're going to end up in the federal public defender's office at some point. Well, almost inevitably. Some are overturned by the Nevada Supreme Court. It's hard to get people into test, but it's a huge percentage. Somewhere north of 30%, perhaps 50%, not competency, but severe mental health issues. Competency, I don't know, a third of that maybe. But it's a significant problem. Intellectual disability is a significant problem. We used to execute everybody, right? Mm-hmm. The youngest person executed in the United States, I think, was 12 when they were executed. Yes, right? I feel the same way. Yes, yeah. Right? And if you think about intellectual disability, we have people with that sort of mentality. We executed the intellectually disabled until a case called Atkins came out about 15 or 20 years ago. We had to go back and look at the people that were on the road to see if they qualified for that, if they were intellectually disabled when they were sentenced to death. Many were. And they were cleared from death row for that reason. So it's moving what our standards of decency are. Now we can't execute people that are under 18. But that didn't used to be the case. We used to line people up. We had a couple on death row in Nevada that were under 18 when they did their crime.
And currently our office is involved in what's called an Atkins hearing, where we're litigating whether a person is so intellectually deficient as to whether the death penalty could even be sought against them. And the state is vigorously trying to kill this person, even though their own doctor says that this person's intellectual IQ is within the 2-point margin of error. So they're within that 2-point margin of error where they could be intellectually disabled. And Steve Wilson's office is still moving hardcore to kill this human being.
At what stage in a case does that fight happen?
The Atkins fight?
Mm-hmm.
Well, so I would love to say, there are qualification requirements for the attorneys that handle capital cases. And you have to be experienced. And I would love to say everybody does a great job. I don't want to disparage other members of my profession. But that said, we've seen a lot of cases where we have what's called ineffective assistance of counsel, where the attorney just fell below the bottom line standards of what should happen in the case. Hopefully, the Atkins claim would be litigated early on. The intellectual disability would be litigated early on. But we see cases that aren't litigated until after conviction. Somebody may have been on the road for 10 years.
Yeah.
So, backing up to procedurally how this works, what is the procedure when the district attorney decides that it wants to seek the death penalty for somebody?
So what happens is the case will go through preliminary hearing or initial screening stage. Preliminary hearing or grand jury, which is lower court, end up in the higher court and district court. Within 30 days of that, they have to file a notice of intent to seek death penalty. And that notice has to have the bad stuff about the person that makes it a death penalty case. A run-of-the-mill murder is not eligible for the death penalty. So the death penalty is going to involve murder of a child, multiple victims, history of violent crime, whatever it might be. There are 14 aggravating circumstances in Nevada last time I looked, and any of those 14 can qualify you. You never have to have a death sentence sought against you. So they have a panel. A panel will meet at the district attorney's office. You come in, and this sounds bad, but I used to call it hangman's row when I'd have to go in and present. And I can look around the table and see who's in the room and figure out if they're going to file or not, as much as the facts of the case. And that sounds horrible, but that's the truth of it. And you present and tell them why they should or should not seek the death penalty against your client, and then they will file. There are some moves the defense can make now that we've been a part of from the Supreme Court that allows the defense a little more time to put together a case to present to that committee. We look for something called mitigation, and mitigation is something that would convince people to lower a sentence. It could be a bad childhood. It could be this intellectual disability that we talked about. It could be all sorts of things. It's a very lengthy and expensive process to find that. People aren't forthcoming, particularly when they have an appointed attorney like me, right, that they don't trust. They think that I'm working with the state. So it takes months to dig those things up, get school records, that kind of thing. And there are some ways to get more time for that. But those things are considered, or hopefully considered, by the district attorney's office. What you hope is not considered is the notoriety of the case or the publicity of the case. But I will tell you, in my experience, cases that are in the press, particularly if they are egregious, are more likely to see a death notice filed than cases that are not in the press. That's just the truth of it.
You want to say something, Craig?
No, I was just going to say precisely what Scott's talking about. I mean, it was part of the major problems which led to the national moratorium on the death penalty to start with. And its ongoing concern is that factors that are driving when DAs are seeking death, and ultimately when the death penalty is imposed, is not connected necessarily to what is the legally relevant facts in a case, such as which district attorneys you're drawing. I mean, and also on top of that, we can talk about the individual district attorneys in Clark County that are sitting on a panel, or we can look nationally at different counties having higher totals of seeking death than others, right? And there's been a lot of media coverage on the fact that Steve Wolfson seeks death much more frequently than DAs across the country. And I think Scott actually has the numbers on that one. But I think the other thing that I just want to say is it is something that is an ongoing concern, especially with the idea of seeking death, that there are factors. I mean, there have been plenty of studies across the country related to the race being a significant driver for who is getting who's getting the death penalty sought against them, right? Who the victims are, like the racial identity of the victims is a major driver for these things. And I think it's also important to distinguish between seeking and imposing and who is ultimately executed. I mean, if you look at the death penalty as in who has been actually executed in the state of Nevada, I think if you just looked at the racial demographics there, you might think, oh, well, we don't have a race problem here. But if you're looking at who's getting the death penalty sought against them and who's getting it imposed on them, that's where the numbers become deeply troubling.
So you've got, and there's two sets of numbers to some extent. And we have to remember how much Nevada's involved, right? I've been here, I call myself a lifelong Nevadan. I came here when I was 20, but that's close enough for most of us, right? I've been here 40 years, give or take. 40 years ago, Nevada was overwhelmingly white. It just was. The demographics were very different. Our population was around 1 million. We are 4 times what we were then. We've become more diverse. So when you look at the historic numbers of the people that are placed on death row, it tips heavily white. Not a surprise. We were 85, 90% of our population was that demographic when I came here. It has changed significantly. The concerning thing is what's happened in the last 10 or 15 years. If you look at the filings in Clark County, and I'll get to why you only have to look at Clark County in just a second because that's very fascinating. But if you look at the filings in Clark County over the last decade, which is our current district attorney's administration, more than half the filings have been against black individuals. That's significant, significantly disproportionate to the population you would expect, right? Another 20% have been against Hispanic individuals. It is vastly, whether it's done on purpose or not, and I don't think these people are intentionally racist in any way, shape, or form, but the proof is in the pudding. If you look at the numbers, at the 130 filings that we've tracked from District Attorney Wolfson's office, more than half have been against black men.
Wow.
And that's been a problem since the 70s. Well,
Yeah.
That's why that case in Georgia stopped it for a while, because what the Supreme Court noted with the facts and evidence that those Georgia attorneys brought up is that when the victim is white and the alleged perpetrator is black, both seeking death happens more often and imposition of the death penalty happens more often. So the Supreme Court put the moratorium on it. And then again, Georgia prosecutors brought it back up to the United States Supreme Court, and the Supreme Court said, well, there's going to be some error, so we're okay letting that move forward. And then we have that same era here in the state of Nevada. And so bias is clearly at play, but nobody wants to talk about it.
Yeah.
Nobody wants to talk about it, but the numbers don't lie. Yeah. This district attorney is largely seeking death penalties against black and brown people over the last decade. And that's a problem. As a percentage of the population, black people in our Clark County make up 11% of the population, but yet they're making up 50% of the people that they're seeking the death penalty against. Yeah. That's a serious problem.
And I also want to emphasize that sort of when you're looking at the different stages, right? When you move farther down the line on the stage of a case, when there's more and more factors coming into play, there are more excuses to explain away why certain things are happening. But at the very beginning, this is in the control of very few individuals that are supposed to be educated about what they're doing and thoughtful about what they're doing, and presumably have the data in front of them to stop, look, and reflect on that. And it's clear from the trends that are happening, that reflection does not appear to be happening about what's going on here.
Yeah, the reinstatement in '76 was designed to tailor. Southern states in particular, you can guess who they sought the death penalty against, and it wasn't a very diverse group. It was really shameful. And the Supreme Court came in and said, if you're going to have a death penalty, you have to narrowly tailor it. And that narrow tailoring comes by this extra bad murders, right? These aggravating circumstances. But we've broadened what that means to where virtually any murder can be a death penalty case if you're creative. And these prosecutors some of the times are creative. So what we tried to do with Greg in '76 has kind of dissipated. And we're back to just shot selection. Whoever they decide to go after, they can go after if they want to. And that is problematic. It's why you saw some very smart people. Justice Kennedy said, famously, "Well, tinker no more with the machinery of death." He just philosophically took a stand against it because he realized, despite the safeguards that we put in, you can't police this and make it fair, and that's problematic.
So the district attorney is the one that decides to file a notice of death, and that then puts it in front of a panel. How do they determine who's on that panel to decide to move forward?
Again, hangman's gallery. It's district attorney, seniors in the district attorney's office, senior attorneys in the district attorney's office. I will go out on a limb here and say that the vast majority of the people in that position are not bending over backwards for a liberal agenda. It's just not what you see in the district attorney's office. Hard chargers end up on the panel. People who want to do the big cases, the dangerous cases, people who want to be in the news. Nothing wrong with that. You want, these alpha types involved in things, but I don't know that you want them making the decisions on who death should be sought against, because there's not a lot of reason that goes on that I can say.
I mean, and so I've not dealt with the panel before. Just to be clear, Scott, are all the individuals on the panel typically people who have handled death penalty cases before and sought the death penalty in cases?
Not always, but a good number are. Okay. Once in a while, you have somebody from appeals come in who they may have done appellate work on that. Once in a while, I have people I can't figure out why they are in there.
So there's no one on that panel that's philosophically against the death penalty. Is that what you're suggesting?
No. Okay. No. That's a much clearer way to put it. I've not seen somebody philosophically against the death penalty in that panel of 12 or 13 people. And if you want to talk about an intimidating situation, like I've done this for a long time, but you walk into a room by yourself with nothing positive to be able to say about your client other than their father left home when they were 8, right? That's the only thing you're saying. You've got 13 individuals looking at you saying, how can you justify the horrible thing that this person did? We're going to try to kill him, right? The person that you represent. It is a intimidating situation. We do our best. And it's a give and take situation too, because if I have something really compelling, I may not want to share it with the other side. For obvious reasons, right? If you get to trial, it may be something I want to bring up later. So it's a very difficult situation.
What I would say is, if we look at it in one way where we say, does this person deserve to die? I think the question needs to be rephrased, right? Clearly they've done something wrong and some consequences need to be attached to that. The true question that we need to ask, though, is do we deserve to kill them? And the power to execute somebody who is behind bars, no longer a harm to anybody, that's an awesome power. And it should not be used unless it can be used fairly, accurately, and humanely. And we have proven that we cannot do that. The number used to be that 1 in 9 people who were sentenced to death have been exonerated. That's a shocking rate of error. That should bug everybody. But now that number is down to 1 in 8.3. That's what the Death Penalty Information Center has put out. So if you were to put your kids on a bus, and in 1 in 8 times on that bus to school, that bus were going to crash, would you put your kids on that bus to school? No. Would you get on a flight that 1 in 8 times that flight would crash? No, I wouldn't fly. I wouldn't put my kids on that bus. But when it comes to the death penalty, we say that's okay. That's an okay, acceptable rate of error. And it's not. So we need to reframe the question. Do we deserve to kill those people? No, we don't. We cannot do this fairly, reliably, or humanely.
And I also want to say there is a confirmation bias, or maybe it's the wrong term, but if you have people who all have grown as professionals in the same environment together, their viewpoints are all aligned with each other, that's not a real check on what's going on here. If you're going to have a panel that's going to be meaningful, you need people outside of that entity, outside of that culture, making that decision. Because the other thing to keep in mind about the death penalty, going back to costs, right, and how long, and Scott's pointed out before how long this is, this costs for the death penalty are astronomical. They ultimately go to the taxpayer. The people who are making this decision, when you think about the panel itself, these are not, D.A. Wolfson's elected. None of the other gentlemen are elected, and they're typically gentlemen, but they're not elected, right? And so in turn, they make a decision where they never actually have to bear the burden for making that decision. They don't bear the costs of that. And the other thing to keep in mind about, there's costs that the DA's office will carry in litigating the first part of this case, but ultimately this is going to shift over on the state, onto a different agency entirely, to continue that litigation moving forward, right? So there's also a lot of, the people who are making these decisions never have to actually carry the weight of those decisions in the long run, right?
Yeah, the political nature of it, if you look at death penalty filings, death penalty resolutions over the last 10 years under the current district attorney's administration, only about 10% of the cases that they file for death end up in a death sentence. Actually, a little less than that. Some of those have already been overturned. So it's a very small percentage. I want to say it's less than 10 out of 129 cases that have resolved have put people on death row, and 2 or 3 of those have been overturned in the interim, and the others are all pending litigation. So it's an enormous cost because the lion's share of the cost for a death penalty case is in the filing. It's not in the back end, kind of oddly, but because what we talked about before, there's mitigation, where I have to look into life background. I have to do that in every case where it's filed. So in a normal murder case, I would look at a 10-minute situation or maybe a day of planning. In a capital murder case, I'm going to look at somebody's entire life. I'm going to look at their father's life. I'm going to look at their mother's life. I'm going to do extensive psychological testing. All that has to be done on the front end, and it is all very expensive. It's interesting that people on the right side of the aisle have started to realize what the costs are. When you look at Virginia, when you look at Utah, they've said, we believe in the death penalty, and if we could do it quickly and correctly and just, take a rope out back and execute these people, it'd be great. But that's not how it works. We've got due process in the United States, and if we're going to give due process to these folks and try to keep the rate better than what John's been talking about, this 1 in 8 or 1 in 9 exonerations, we have to do better. If we're going to do that, it's just too expensive. Because if you think about it, 1,000 death penalty cases sought, give or take, in Nevada, 200 people sentenced in the row, to send one non-volunteer to execution is the biggest boondoggle I can think of. And there's a lot of boondoggles in government. We've worked close enough with government to see where the money's wasted and lost. This is probably the number one expense, more buck for less bang than anything I can think of in the state of Nevada.
So the expense is primarily in the fighting of the case and the legal battles that happen, not the expense of the few that actually end up being executed?
Absolutely.
Although, Scott, I do want to mention, they built a brand new death chamber up at Ely State Prison that has not been used.
Well, it's
right?
better than that.
Well, I mean, you want to share the details?
Yeah, so under Laxalt, we built a death chamber, spent $1 million to build a new death chamber at Ely. It's never been used. We've now moved death row from Ely, or in the process of moving death row in Ely. So we spent $1 million to convert a interview room to a death chamber. When you go in to interview clients there at Ely, you can see the bed and things laying out where they will do the executions while you're talking to your client in the other room. Never to be used. Even with all hope, from my perspective, never to be used. But we've not used it in the last 15 years.
Right.
Again, that's just money down a hole. But if you're a politician and it's not your money, let's build it. Let's do it. Let's make this thing go, right? We will charge hard and we will protect people. Truth is, it doesn't, right? I mean, states with lowest murder rates, interestingly, don't have the death penalty. Kind of shockingly, right, when you actually look at the numbers. Because I think there's something about the death penalty that cheapens human life that we don't think about that much. But it's everywhere you look, there is wasted money, wasted time. Very few of these cases are going to trial, even we're resolving 2/3 of the cases by plea agreement. And if it's a moral imperative that this person have to die, which is what you would hope if we're judiciously using the death penalty, how does it make sense that we're negotiating 2/3 of these cases? That seems kind of contrary, but that's what we see in the background. I wanted to mention something about Clark County, if I could, real quickly, because Clark County, John used the word outliers earlier. And Clark County is an outlier of outliers when it comes to death penalty. And what I mean by that is we currently have the most pending capital trials pending of any place in the country. The most in the country. There are 3,000 plus counties in the United States. We are number one in absolute terms. We are number one in per capita terms. We have about 60 pending capital cases in Clark County. Los Angeles County got rid of all theirs, but before that, 5 times our population had 30 pending at the peak. California, Riverside County, about to go bankrupt because of death penalty filings, had 48 at the peak. They're the same size as us. We've got 60. All those counties, by the way, Riverside, Pennsylvania that John mentioned, Maricopa County was a death penalty hotbed, as pointed out in numerous articles, including the American Bar Association, have reduced their numbers because they've realized that it's just not, people weren't being selective in how it was sought. It was problematic, it was overwhelmingly costly, and those numbers have come down every place, but not in Clark. If you look around the rest of the state of Nevada, we've got 60 in Clark. What would you think we might have in the rest of the state? How about this? How about 1 pending capital case in the entire rest of the state of Nevada, right? Because it's too expensive. Small counties, Churchill County, Douglas County, it's too expensive to prosecute a capital case, which is part of the hypocrisy of this whole thing. We see testimony that district attorney's offices don't spend any more money to pursue a capital case than they do a non-capital case. We got people and they can show up and do their work either way. But when we had the gentleman that was involved in 4 homicides in northern Nevada, 2 in Douglas County, 2 in Washoe, the district attorney from Douglas came out and said, we can't afford to prosecute this case. And they ended up negotiating that case for something other than capital punishment. Clark County happens to have money. And because they have money, we can throw it at things like the death penalty. And that's problematic, right? Whether or not you get a death sentence shouldn't depend on where the gun was fired. It shouldn't depend on if your feet were in Churchill County or Clark County. But that's what we see.
Wow. So Clark County is number 1 per capita and overall numbers of people who are currently in the process of going through a trial where a death penalty is being sought?
Yeah.
We're a big time outlier.
Yeah.
Yes.
And that's under this current district attorney, right? And a lot of whether or not somebody gets the death penalty sought after them comes down to prosecutorial discretion. And there are more conservative district attorneys across the state of Nevada that seek to use that discretion less than Steve Wolfson, who is the district attorney
But-
here.
Well, not just the state of Nevada, we're talking across the country. I think that
Yes.
people often think of that we are better on criminal legal issues than the states in the South, Louisiana, Mississippi, and Alabama. But in this instance, we are not superior, have moral superiority over anybody in those states on this particular issue.
To give the devil his due, Steve Wilson's predecessor, David Roger, had 80 pending at one point, even more. And we have reduced the numbers by 15% or 20%, which if you talk with Steve Wilson, I've talked to him about it, we've appeared in front of the legislature together on this, will say, I've reduced things. That's true, he's reduced things by 20%. The problem is the rest of the country's reduced things by 80%. We are out of step with everybody. The federal government, we're out of step with every jurisdiction that I can think of. And that's problematic.
Wow. And so once there's been a notice of intent to seek death and this panel of prosecutors decides, yeah, let's go ahead and do it, what does that process entail for these 60 people that are winding their way through that system?
So hours and hours and hours of work and interviews. There's a National Judicial Council, I can't remember the exact name, something along the lines of National Judicial Council. Looked at the hours spent to defend a capital case versus to defend a non-capital murder case. Average attorney time, non-capital murder case, 750, 800 hours. Capital case, 1,800 attorney hours. And that was 10 years ago. I will tell you from practicing in this field, it has gotten substantially more than that. You have to have 2 attorneys on a capital case, for example. There's a higher pay rate for attorneys on a capital case. There are all kinds of things that go into it. There are more experts in a capital case. So they're going to be sent for brain imaging in every case that I have. I'm going to try to find mental health history. I'm going to dig up school records. Nevada is a transient state. That means sending people to Arkansas, to Mississippi, to Cuba. I tried to get into Cuba one time to try to get health records. That's not very easy to do. We're going to dig for all those things to try to figure out what in the past led the person to this point. And it takes years. Normal case might pend 3 years, normal murder case, maybe 2.5, 3 years for resolution. Capital cases are upwards of 5 generally. So it's a long time to resolve.
So if we were to generalize that across our profession, right, a new associate's billables maybe 1,800 hours to 2,000 hours, right? That's dedicating that associate solely to this case every day, all day long. That's all they work on. And frankly, that's a bare minimum, really, if we're talking about killing somebody, right? If you are the one that has the accusation against you, you want somebody putting in as many hours as they possibly can.
Yeah.
And that's during that phase from when they decide to pursue the death penalty up until they actually get sentenced to death, if they
Right.
do.
So they get sentenced to death. And a jury has to do that.
And so are there any special requirements for a jury that can sit and hear a death penalty case?
Part of the problem with it is you can't sit on the jury if you don't believe in the death penalty.
Yeah.
You get eliminated from the jury.
So we'll lose 40%. Anybody that's a conscientious objector is going to be eliminated.
And
Wow.
I think that's an important thing to keep in mind is that obviously as more people become aware of the problems with the death penalty, more people are becoming objectors to the death penalty because it is a logical, rational reaction to what, like anyone who actually knows the nature of the death penalty, what they would do. But because the Supreme Court has ruled, oh, well, if you can't consider death as something that you would impose here, right, if you're just going to say no, you can't be on a jury. So all you have left is, again, people who are rejecting the information that's becoming clearer and clearer all the time, that this is an unjust sentence that has no rational basis to be included in our criminal legal system. So again, it becomes, the juries become harsher and harsher, and there's no countervailing idea of, there's very few people who will just simply say, I will kill this person no matter what, right? Most people will be like, oh yeah, I'll consider it, but you can tell that it's not a real consideration. If the idea is if I convict you of this murder, I am going to kill you, is something that definitely is crossing through people's minds.
And is it the same jury that is selected of only people who will put someone to death that hears the guilt versus innocence part of the trial as well.
Yeah, and there are studies, academic studies, law review published studies that say those jurors are substantially more likely to convict, right? You tend to get conservative jurors who believe in the death penalty, jurors who are more likely to convict. That creates its own problem, and it perpetuates what John talked about with the wrongful conviction of innocence, because people are pre-inclined to believe the state's position, to believe officers, to think somebody's done something wrong.
And to be fair, I mean, I don't necessarily, you mentioned conservative. I think that perhaps you mentioned previously, though, that there's been a growing bipartisan resistance to the death penalty. And so I just want to maybe reframe that. People who believe that the state can competently execute someone are also the people that believe the state is competent even when they're not, when they're hearing evidence in the guilt or innocence stage, right? If you're predisposed to think, oh, they must do this properly, you're also going to think, oh, they must have investigated this properly, or that they had their evidence, this prosecutor is presenting this properly.
No, you're right. Our government is questioned from the right.
Yes.
Very,
we'll give them some credit.
No, very often now, and you would think they would make great death penalty jurors. Now, I personally would not leave them on a death penalty panel, but I understand the point.
So, John, you mentioned earlier that there's an 8.3 rate of cases that actually get exonerated after somebody's been sentenced to death. So we have the panel that decides whether or not to pursue the death penalty that's made up only of prosecutors, and we have a jury that decides whether or not someone's guilty or innocent, made up only of people who believe in the death penalty, and then the ones that decide whether or not they get the death penalty, made up only of people who decide who believe in the death penalty. What other factors also contribute to these really high rate of innocent people being sentenced to death?
So from 2007 to 2017, the leading cause of wrongful convictions was official misconduct. And I want to talk to you a few about that, because maybe you think that's only a nationwide problem, but it's actually a problem here. Demarlo Berry, who was recently exonerated, they originally sought the death penalty against him. 20 years later, the Rocky Mountain Innocence Project came in. We had an attorney that left our office to go work in Wilson's short-lived conviction integrity unit, looked at the facts of the case, said this is not a good case, and had Demarlo released. Kirsten Lobato is another person that was innocent. The Innocence Project had to come in and exonerate her as well. Go ahead.
You may also just want to mention how with Lobato, how did District Attorney's Office react to efforts to have her released?
Oh, they were very upset. They fought it to the very last minute and eventually relented and said she served enough time, so we're good just letting her out.
But
taking no concern over convicting an innocent person. And then probably another alarming one that still has repercussions in our legal community today is Fred Stees. He was wrongly convicted by people who were both on the bench. Now, one is still on the bench and went up to the Nevada Supreme Court, but both of them as district attorneys hid evidence and wrongfully convicted Mr. Stees, right? One of them got removed in the election, William Kephart. The other one, though, is now on the Nevada Supreme Court. And Mr. Stees spent 20 years behind bars for a crime he did not commit. And instead of, after a judge had made a finding of factual innocence, and after waiting 20 years, the district attorney's office, instead of freeing him, said, well, you can take this Alford plea to this lesser category D felony, which is a 1 to 4 year penalty, and be free now, or you could wait for your trial, which could take many years. And so Fred Stees opted to take that Alford plea, right? So the district attorney washed their hands of it, absolved themselves, and Fred Stees went to the pardons board and was fully pardoned.
And received, if I'm on the conservative side of things, and received a substantial judgment from the state for the wrongful conviction.
Millions that we paid.
That's
So
two that we're aware of that in that situation. Miranda, not the big Miranda that we all hear about, but Nevada Miranda was a $5 million payout by the county years ago.
So our county has had to pay out judgments to people who were sentenced to death and later found to be innocent due to
Correct.
prosecutor misconduct.
And we are one of the few states that actually does that. So we actually try to make it right, but I don't know that any amount of money could give me 20 years back of my life. Mr. Berry, probably one of the nicest people you'll ever meet in your entire life. You know, he was in Assemblyman Ira Hansen's office. Assemblyman Ira Hansen has 8 kids, a ton of grandkids, and he looked at his family and you have a very beautiful family. That's what he said to Ira Hansen. And Ira Hansen, who is very conservative, was moved. He is one of the people that voted for compensation for the wrongfully convicted, because he realized that no matter what amount of money we give Mr. Berry, he has missed his whole life. He has missed raising children. He has missed seeing those children go to high school, to college, to go on to do great things. He's missed all of that.
And look, the attitudes are problematic, right? Because this is a big ticket item as far as if you're a competitive attorney in the criminal justice realm, right? Prosecutors want a death sentence and they want to protect them at all costs. And that is problematic. We talked about Stace. I had another prosecutor who's now on the bench tell me one time, we lose people in war. What's the problem if we lose a few innocent people to death row? Yeah. You want the hairs on the back of your neck to stand up. I had a prosecutor that told me that one time when we were talking about a case. Very, very problematic. They fight to maintain these things, to maintain the status quo to their last breath. There was recently someone who was factually innocent of the death penalty. And what I mean by that is, under the current law, they're not eligible for the death penalty. And this prosecutor's office went to the Nevada Supreme Court and said, yeah, but they were eligible before we knew part of it was thrown out. They waited too long to say that they're not eligible for the death penalty. Let's execute them anyway. That is problematic. Nevada Supreme Court luckily disagreed with that, but that is a problematic stance when we get to that point. There were no aggravating circumstances left for this person. And they said, yeah, you didn't bring it up soon enough. Let's just go ahead and kill you. It's a bad attitude.
And that's something I want to emphasize, because I think sometimes people can wonder, well, I mean, the death penalty affects a small number of people in the criminal legal system. Why is this so important? But it is a bellwether for the rest of the criminal legal system. And maybe an important thing to really emphasize is that the folks that are making these decisions in a district attorney's office are the people at the top, right? This is probably the clearest way to see their attitude about defendants, about liberty, about their power and when it should be imposed. And that pours down onto the rest of who's in there, right? Who is incentivized? You talk about the misconduct situation, right? You can ask the question, are the prosecutors in a particular office incentivized to do the right thing, right? Or can they engage in misconduct and be rewarded for it? That's in what we've seen, right, historically as things play out, is that with these misconduct type cases, these are people that ultimately ended up having very successful careers inside that office and then beyond that office, right? There's no consequence for this kind of behavior, right? Versus if someone looks at a case, if you talk about a prosecutor that looks at a case and says, you know what, I think this person's factually innocent. I'm going to dismiss this case. And it's a serious case, right? You're talking about a murder type case. That person's not going to be rewarded for that, for making the right decision, for making the right call, right? That person will be questioned for making that decision. And if they made the right decision, they will not be, even if they are acknowledged to have made the right decision, they will not be rewarded for making that decision. And I think that's something that people, and so in turn, if you go back to the original panel we're talking about, these are individuals that rose through the ranks and got where they were, not by recognizing and looking for the innocent person, or recognizing and looking at the mitigating evidence and saying, look, I'm going to do less. I can go full bore, but I'm going to do less. These are individuals that successfully went full bore over and over and over again.
I don't think anybody that I'm aware of purposely puts an innocent person on death row. I just personally haven't seen it in the district attorney's office, but things are overlooked. And people get overzealous, and you make your bones by being a tough prosecutor, not by being an easy prosecutor, right?
Well, I want to rephrase that. It's not being about being a tough prosecutor or being an easy prosecutor. You make your bones by being a tough prosecutor. You don't necessarily get rewarded for being wise, as seen by Fred Steese, right? You don't get rewarded for possibly being a just prosecutor. And I think that's it. So it's not about being easy,
You're right.
Because it's their framing when they say it's easy.
You're right. And one of the things that criminal justice realm, we look at something called prosecutorial misconduct. That is where a prosecutor comes in and does something really bad, like hiding evidence in the Fred Steese case, which was just inexcusable, right? Independent survey looking at capital cases for outlier counties includes Clark, because Clark is this tremendous outlier county. It's either the 2% report too broken to fix, or oh boy, I can't remember the other report, but one of these reports looks at prosecutorial misconduct. What they find is decisions relating to Nevada death penalty cases, highest rate of prosecutorial misconduct in the country of the people that they looked at was noted in Clark County. Something like 35 or 40% is noted in the published decision, some kind of prosecutorial misconduct. And prosecutorial misconduct, by the way, has to be egregious. I mean, it's not playing fast and loose with the hearsay rule. That's not what we're talking about. We're talking about hiding evidence. We are talking about, well, look at him, he looks guilty, come on now. It's those sorts of things that are really inappropriate. We had an extremely high rate. The reversal rate here in Nevada is more than 50% when a death sentence is handed down. More than 50%. So even when they get this 10%, half those are going to get thrown out. I, years ago, put together a chart, a spreadsheet, and I decided to color code things. Sometimes you can see things when colors come out, right? And I put red for reversals and white is cases that weren't reversed. And what you see, if you look back in time, is a flush from white to red. The longer these things sit around, the more likely they are to be reversed. So while I say it's a 50% reversal rate, that's of all death sentences. If you go back to death sentences before 85, you're getting closer to 65 or 70% reversal.
And who is it that reverses death penalty sentences?
Sometimes it's the Nevada Supreme Court. Sometimes it's the U.S. District Court for the Federal District of Nevada. Sometimes it's the Ninth Circuit.
Yeah. Sometimes it's the district court second time around where they come back for what's called a post-conviction relief petition, where somebody's really done something and somebody hid, like the Fred Stees case. Things were hid so well it took years to uncover the problems. And that happens. So there are safeguards, but it doesn't mean we get it right every time.
Yeah, I mean, I think that's something, you know, as you go along in the appellate process, you start getting to some more, you get to start getting some more procedural aspects that they're appealing on. But I mean, the United States Supreme Court has signaled that they will accept the execution of an innocent man at some point, right? And that's something that is deeply disturbing and Kafkaesque when it really comes down to it, that at the end of the day, it's, well, you know, due to these procedural rules, you can't raise these issues anymore. It's actually something that has come up recently. There was an appeal before the Nevada Supreme Court where the Federal Public Defender's Office was offering evidence that the individual that was on death row had a severe mental illness, and that there should be a hearing related to that. And the Nevada Supreme Court basically said, due to procedural grounds, they weren't going to consider that evidence.
Yeah, but Kafkaesque case for certain. Remanded for a evidentiary hearing because the attorneys hadn't put on mental health defense. Vincenzi, I think is his name.
Yes.
Venisi hadn't put on mental health evidence. Venisi comes in and says, nobody put on mental health evidence for me. They remand it for a hearing. Venisi comes in and says, I changed my mind, representing himself, barely competent to move forward.
Because he's severely mentally ill.
Severely mentally ill. And Supreme Court says, well, you know, you don't have to have the evidentiary hearing. It's okay.
Right, because he waived it.
Because he waived it and he was competent to go forward to represent himself, which is a constitutional right. He was allowed to waive this even though he's severely mentally ill. It's not a trial. It's not. I mean, there's all kinds of reasons that it doesn't make a lot of sense. We wouldn't let him waive appeal of a death sentence, for example. There's a statute that says that. But just a very...
And if I could paint the picture of competency in that case, because I watched some of the arguments, they were saying this man was competent, but he was saving up plastic water bottles to build a spaceship to leave the Earth. And that's a person they said was competent to proceed on his own.
Yes, and to be clear, that he would be handling a case that if you have a lawyer handling it, there are clear rules dictated by the Nevada Supreme Court on who's allowed to touch a case and who's not allowed to touch that case, right? But this gentleman who's building a spaceship out of water bottles, oh yes, he was in the right state of mind to waive the hearing that would have established that he was severely mentally ill.
And is there any obligation on the prosecutor or the judge to flag that or not proceed or not allow a mentally ill person to waive his rights and proceed without representation?
You would think so, Emily, but I feel like our criminal justice system tends to turn a blind eye and use procedural rules to not get to the real merits of things and look at the problems of things that are occurring. And this just happens to be the most glaring issue because we're talking about killing people, so it gets the highest amount of scrutiny. But as we've talked about, we're still so error prone.
Yeah, and look, it's a difficult situation for these folks, right? Because again, it's a constitutional right to represent yourself, and that makes sense. Although in this context, boy, it's a very dangerous thing to do. But what do you do when somebody is severely mentally ill but still meets that bottom threshold? And part of the problem is that threshold is so low. This brings us full circle, by the way. Remember I said we had one person who was executed against their will? That was a guy by the name of Richard Moran. He was involved in killing some bartenders, long history of alcohol and depression, severely mentally ill. The case that says you have the right to represent yourself so long as you're competent, even in a capital trial, just like a traffic ticket, is Richard Moran's case from here in Nevada. That was litigated because he represented himself in front of a 3-judge panel, which is no longer constitutional. He asked for the death penalty when he originally went in to the 3-judge panel. At some point he decided to appeal, and the basis for the appeal was whether or not, with this severe mental illness, if he was just this marginally competent, he could represent himself in a capital trial. The Ninth Circuit reversed, the U.S. Supreme Court reversed the Ninth Circuit. So Nevada's got a history of playing with these mental illness issues.
I would also point out, I mean, they're really disturbing. So there's a couple things that are actually also missing when we talk about the criminal legal system during this, right? When you asked, did the prosecutor or did the judge have something they need to say? People view the criminal legal system as though the prosecutor and the defendant have the same objective. That is inaccurate. That is not true according to the rules of ethics. It is perhaps true in practice because people are not thinking deeply about the moral implications of what they're doing. But the reality is that prosecutors do not have a duty to win their case, right? They have a duty to do justice according to the rules of ethics. And so actually, under these circumstances, ethically speaking, if a prosecutor recognizes someone is severely mentally ill, they do have an obligation to have that hearing and say, we're not waiving this hearing, we need to have the hearing, right? Because they have an obligation, again, not to just dunk on severely mentally ill people and drive them towards a death chamber. That's not what they should be doing. But the thing is, we say, oh, well, he's representing himself, so therefore we're all trying to win here, right? That's the mindset that comes into play. And when the idea is winning is getting a guilty conviction and getting the most severe penalty that you can get, if that's the objectives that are laid out ahead of time, it's like, oh, and this would be too complicated for me to think about the moral implications, then that person should not have the power to be driving forward in the criminal legal system. I think the other thing that's also missed here, right, is that the criminal legal system, as it is under the current framework of two sides trying to win at all costs, ignore the fact that the criminal legal system is fundamentally different than the civil system, in the sense that we as a community have an interest in the criminal legal system, right? It's why it's the state of Nevada versus an individual, not two individuals against each other. And I think that's something that's often missed. And then in turn, we have a criminal legal system that's become incredibly transactional, right? Well, he's representing himself, so he's allowed to do whatever he wants. But we as a society should be asking, well, we have an interest in not having severely mentally ill people killed in our name.
Yeah, right. And in deference to the judge from Washoe County, it was Judge Steinheimer in the Venesi case. She did have 2 evaluations that said he was competent to move forward. Now, the evaluators met together, which I have to think is questionable ethically for a psychologist not to do an independent evaluation, and they spent about 5 minutes with Venesi. So whether it was a legitimate competency evaluation, I think there's some red flags. Put it this way, if it was a case I was handling, a case one of these gentlemen was handling, we would have a doctor in to spend hours to figure out what was going on, because mental illness isn't readily apparent in 20 seconds or 30 minutes necessarily. And that's part of the issue is if there's no attorney, nobody has the contact with the individual to be able to flag these things. The judges are obligated to do it. There are cases that say you're obligated to stop if you have questions about competency, but the standard is so low.
Yeah.
You mentioned earlier that there's certain requirements for when an attorney is appointed to represent someone who is facing the death penalty. What are those requirements?
Scott, if you
Scott, you want to cover
So there's Nevada Supreme Court Rule 250, and it says you have to have 5 years practice, you have to have done 5 jury trials through completion, and you have to have sat second chair on a capital case. It's a fairly high bar. It narrows the selection substantially. That is for appointed counsel. If you wanted to hire somebody, you could hire a brand new first day barred law student. If you wanted to hire somebody, it's a choice of counsel issue. Now, truth be told, counsel is appointed in 98+% cases, or at state taxpayers' expense for capital cases. Almost all of the 60 pending, we've got a couple people that are representing themselves. I don't know if there are any right now that are paying for their own counsel. Maybe there's one of those 65. The rest are paid for at state
Wow.
expense.
It's just
So-
too expensive, right?
Yeah.
I mean, has
And
anybody
they don't seek death against the rich.
Yeah.
Let's be honest.
has
fair.
anybody looked at how many times there's been a notice of intent to seek death filed when somebody is paying for a private attorney to defend them?
Well, that decision usually comes early in the process, so it wouldn't, I don't think the decision on whether to file would necessarily turn on whether it's private or appointed counsel. The assumption, and I hate to say this, but the assumption is if a private attorney is representing somebody at that person's expense, the person's going to run out of money before they get to trial. And it's going to end up with my office, with a special public defender's office, or we've got an office of appointed counsel that pays legal fees for outside counsel when there's conflicts. They have about half the cases right now. But the assumption is the state is going to be on the hook at some point. Even if you pay for an attorney, there's a case called WITIS and something called WITIS funds. If I'm a private attorney and you hire me to represent you on your capital case, I can petition the court to pay for my experts. So the county still ends up paying for it.
Yeah, the experts are not cheap.
Yeah.
And if I may, I think if we just if we could even generalize it really to, we have a system that treats you better if you're rich and guilty than if you're poor and innocent. And that became abundantly clear under this district attorney, if I could. There was a billionaire that was running the Marcy's Law bill through the state of Nevada. And Steve Wilson was doing ads for this billionaire on Pandora and all across the state. While he's doing ads for that, this billionaire comes here and he gets caught at the Wynn Hotel with a level of drugs that would have imprisoned any one of us here.
I think we'd all say it's 3 to 8 years in the Nevada Department of Correction at least.
Oh no, it was 10 to life.
Yes, well,
all of us would have served.
Let me rephrase that. We're talking 10 to life is the charge. The classic negotiation that is offered by the Clark County DA's office for this sort of charge, if you're represented by a public defender, 3 to 8 years. That's what you're doing.
So the level of drugs this gentleman had on him that he was caught with
was an incredible amount of drugs.
is something that would have put us all in prison for a very long time. And instead of prosecuting this billionaire for that, they continued the hearing and continued the hearing. During these continuations, Steve Wilson is still appearing in ads for this man's bill for the Victims' Bill of Rights across the state of Nevada. After that gets passed, then they move forward with the prosecution and they deal it to a probationary deal where he has to pay, with a drop down to a non-felony offense, where he had to pay $1 million, I think, to some
$500,000.
to some treatment program, which really represented like 0.00025% of that man's net worth. So even here in Clark County, you are treated better
You can
if you are rich and guilty
pay your
than
way
if
out
you
of
are
prison.
poor and innocent.
Yes, you can pay your way out of prison.
So you guys had mentioned earlier that there's Zane Floyd who has an execution that has stuff going on with it right now.
Yes.
What's going on with that?
So he is currently being represented by the federal public defenders on his case. We also have litigation related to Zane Floyd's execution that's pending before the federal courts. We're currently waiting for a hearing. We're representing the Nevada Press Association in that case. So going back to the idea of there are people outside of a case that have obviously interest as far as what's going on in a case like Zane Floyd's. A key thing to keep in mind is that the general public has a First Amendment right to access related to government activities. Sort of the classic place where we think of that actually is the courthouse, right? That I can walk into a court proceeding, and if I'm barred from walking into the courtroom, that's not a right that belongs to the defendant, it's not a right that belongs to the state, it's a right that belongs to me to observe what's going on and knowing what's going on in my courthouse, right? This extends to executions, all right? While the prisons can put some limitations on who can attend an execution due to safety reasons, because they typically occur inside of a prison, at the same time, we have a First Amendment right to know what's going on with executions. And there's been a significant amount of litigation that's occurred in the Ninth Circuit related to that, first in California and then in Arizona. Because the idea is going back to what we talked about with the pharmaceutical companies. The states are frequently trying to hide what's actually happening and present an image, especially with things like lethal injection, that this is a painless process, this is clean, this is clinical. They basically want to make it look like it's a medical procedure. The reality is that executions are regularly botched and horrifically botched. And you need to have independent viewers watching that, observers watching that, to make sure that that information about what is actually going on in execution is getting back to the general public. So under the law and under the First Amendment, the prisons do need to make the executions available to the press, and they have to show the execution from the moment the person enters the death chamber until that person is deceased. And the reason why that's so important is, actually there's an example of that recently. There was a gentleman that was executed in Arizona where they started putting the drugs into his system and things clearly went very, very wrong. He was clearly in significant pain, suffering, moaning, like there was, anyone watching that could see that things were going horribly wrong. And they dropped the curtains so people couldn't observe what was happening, although they could still hear the sounds he was making. It sounded like he was drowning alive, is what they were saying. And the Arizona government said later, oh, no, the execution basically went off as planned. And it was the independent reporters who were saying, no, this did not go as planned. This went wrong, and we should have been allowed to watch what was happening. And the Ninth Circuit agreed that if you're going to execute somebody, we will also watch it when you do it incompetently, so the general public can decide for themselves whether or not this is something they want done on their watch. This also ties into something else that we're dealing with here, that we are also litigating, which is the chemical veil, which we talked about previously, which is a drug added to the drug cocktail solely for the purpose of making an execution look clean when it's not, right? That if something goes wrong, the general public won't know what's happening. And so it raises a question about what can a government do to essentially lie to the public, right? Are they allowed to do things specifically to hide things the public would obviously have an interest in when they're making decisions about whether or not they're going to ask their state legislator to pass laws to end the death penalty in the state of Nevada? And it comes back to something that's very, very important to us here in the state of Nevada, right? Because of the fact that it is something that is an ongoing question that our public's grappling with, but again, whether or not we want this in our name. It also ties back into our history in the state of Nevada. And when you talk about things that have the history of the death penalty here, for example, we were the first state to kill somebody with a gas chamber back when it was first implemented. And our state government said that that went well when the execution was completed. They successfully killed the gentleman that they were using the gas chamber with. The description of what happened by the independent journalists was very different. Again, talking about someone who is basically sounded like they were drowning alive with the fresh air, that the way that they had not mixed the chemicals properly in what was producing the lethal gas, that there were people in the chamber, outside the chamber, that were getting sick because they hadn't properly sealed the chamber, right? And there were newspapers that had come in from California and all this that were simply saying this is a clear sign of just barbarity is happening in the state of Nevada, right? And so you need this check on government conduct, and the government is doing whatever it can to limit access to see what is happening so that, you know, the public doesn't know that the government is messing things up, or doesn't know that really what's being done in their name is gruesome, because killing someone is gruesome.
Yeah, and Floyd's being litigated in state court too. There's a real interesting separation of powers issue. There was a repeal effort unanimously passed with the Democratic side of the Assembly last session. Furthest death penalty repeal has gotten in Nevada because of the problems we've talked about today, and they're obvious and documentable. But it died in the Senate. The leader of the Senate, Nicole Cannizzaro, worked for the Clark County Prosecutor's Office. and the head of judiciary, Melanie Scheibel, works with the Clark County Prosecutor's Office. So there's current litigation pending concerning separation of powers, whether it's appropriate for those prosecutors who may have a vested interest in their litigation futures in the district attorney's office and promotions and that sort of thing, making the decision for the rest of the people of the state as to whether or not we should have the death penalty. It is problematic. The Nevada Supreme Court's not made a decision on that. There's a couple of separation of powers. Very esoteric legal concept, but separation of powers suits pending. There are Zane Floyd's being litigated on multiple fronts. One of the most concerning things, COVID affected everybody. It affected the death penalty too. You wouldn't think of that, but the commutation board hasn't been able to meet. And Zane Floyd has a due process right to have his case considered by the commutation board. He was sentenced to death by a jury that was very different than probably a jury we get today. They took days to reach a decision on his verdict of whether or not he should live or die. He suffered from post-traumatic stress disorder. There's not much question about that. Has been a model prisoner, and he wants a petition for commutation, which everybody else has a right for. But the commutation date moved because of COVID. They couldn't convene the panel. Rather than possibly delay the execution, the state of Nevada walked in and said, we need to execute him anyway. Forget about the commutation board. Forget that everybody else has a right to do it. Anybody on any prison sentence has a right to do it. We should just execute him anyway because we're having problems getting the drugs, because we might be forced to disclose the identity of the people that are involved in the execution. It's all very Star Chamber-ish, and it's very problematic.
And actually, Scott, I just wanted to go back really quickly. I think there's two additional facts that I think the federal public defender brought out in their litigation before the Nevada Supreme Court related to the separation of powers issue. One, Wolfson has made it pretty clear through his public comment that the decision to move forward with Zane Floyd's execution was related directly to the bill that was pending and had passed through the House. So there's no secret that he had a political interest in seeing the bill die. He made it very clear publicly. I think the second thing I think was emphasized was the way that the bill died. It didn't ever get a vote in the Senate. Basically what happened is it got successfully passed through the House, and it died on the table in the Senate Judiciary Committee, which Melanie Scheibel was the head of, and Nicole Cannizzaro was the second in. So it does raise some questions, and I think that something that is important to come out of that is, whether or not what actually happened or what was actually in people's minds, that's one thing. But there is an idea of public confidence that the prosecutor's office is not having an undue influence, the executive branch, the prosecutor's office is not having an undue influence upon the legislative branch. And going back to separation of powers, how it's applied and the way the rules may apply may be esoteric. I mean, I might respectfully disagree there. Right. But I think the fundamental principles, especially from the perspective of the ACLU, is not esoteric, right? That one of the most important ways that we ensure that the government does not impinge upon our civil liberties and our civil rights is to make sure that the people who are enforcing the laws and wielding the power are not also the ones dictating what the laws are, right? And that's something that we take very seriously at our affiliate, and we think that's a very important principle. How it applies in practice might be slightly more complicated to make sure that it fits properly with and that a just outcome comes out of that. But it is something that we do need to take seriously, and separation of powers should not just get lip service. It's something that should be implemented in our society.
Fundamental.
Yes.
Yeah, I think absolutely fundamental. Yeah. So, how the bill died last session was, I think, interesting and a bit telling. There was a statement by the governor. John was actively involved in legislation. I was actively involved in the bill. The statement essentially said we haven't had time to vet things, which is very disturbing for people like myself, people like John, who've been working on the front of this issue for decades and been arguing with district attorneys for decades to get that far into the session as far as we did, and to hear we've not had time to vet things or have discussion from interested parties seems, it may well be true from the governor's perspective, but it comes across disheartening and a little disingenuous, to be quite honest. But we've got time now. That's why programs like this are great, right? Because we hope to have that discussion now. If we didn't have discussion before, the table's open. I'm certainly willing to sit down. John's willing to sit down. Chris is willing to sit down.
Well, our policy director would be willing to sit down.
Understood.
I usually come in when we decide to sue someone. So
Understood. Understood. But the point is, Open Table would like to put all these things out there. Look, public information, I am confident when the public knows how broken the death penalty is, there's not going to be a lot of support for it because it really is broken. By the way, I didn't come to this as a death penalty repeal sort of person. I came in from the other perspective. I'd spent a summer in the district attorney's office in Reno in law school. But seeing how the sausage was made, for lack of a better description, has really soured my taste for sausage. It's a mess.
And so the last legislative session, they had a bill to repeal the death penalty that passed the House and then just got stuck in the Judiciary Committee that's headed by 2 prosecutors.
yes.
Is there an expectation that there will be another bill to repeal the death penalty brought in a future legislative session?
I think as long as we're alive, we're going to keep trying to abolish it because none of us here on this panel want to see somebody die on our watch.
And the hopeful thing in Governor Sisolak's comment was there hasn't been enough time where he's comfortable with the discussion. Now we've got some time. Now let's talk about stuff. Let's sit down and talk about things, figure out where we're at.
And again, the legislature is not my area of expertise, but it was my understanding that the bill had bipartisan support, that people had come out from both sides of the aisle.
That's correct.
Yes.
I wish it would have been more bipartisan in the Assembly, but there was bipartisan support in the Senate.
And so what things can be done by anyone who cares about this issue to, assist in the effort to have this legislation actually get through the legislative process next time?
I think joining the Nevada Coalition Against the Death Penalty, joining the ACLU of Nevada, I think contacting your legislators and your state senators and letting them know how you feel, so that they understand how their constituents actually feel about the death penalty, so that when they're moving forward on a vote, they feel the most informed. I really appreciate you giving us this forum to talk about this. It's a pretty depressing topic, but it's a topic that needs to be talked about and dealt with as we continue to grapple that, so that Nevada is not last place in this too. We're last place in a lot of indicators: education, access to mental health resources, access to drug addiction resources, and we're moving forward in Clark County, especially in seeking to kill the most people. So I think we have an imbalance of where we are in our community, and I don't think that's a fact that's widely known. And I think once more people, as Scott said, become aware of it, maybe we can move forward in a better direction and stop trying to kill people so often and actually use some of that money for our schools, for our mental health crisis, for our drug addiction crisis.
And I would say, that this panel, obviously we've got public defenders and former public defenders, but I'm willing, I think John's willing to sit down with prosecutors, anyone else to have this discussion, because I think the facts are pretty clear once they get out there. I think hiding the facts, putting a veil over the facts is what's kept the death penalty in function as long as it has.
And I think that's something I would emphasize off this. I think this is a great program, a good place to start becoming educated. One thing I would tell people to do, though, is that if you're trying to get a grasp on the nature of state power and its relationship to the criminal legal system, the things that are wrong when you take a bird's eye view and look down on it, the death penalty is a good place to start, right? And to do the research there, to do a deeper dive, and to get a good grasp on what the numbers really are and what's happening on the ground, that's an excellent inroad onto understanding the deeper problems that we have with the criminal legal system and the reality that we do not really have checks on the most significant of state power, and that needs to change.
Thank you.
And I thank you.
Thanks.